Thank you, Chairman Lewis, Chairwoman Hogan, members of the committee, for this opportunity to discuss House 1991, an act affirming a terminally ill patient's right to compassionate aid in dying. I became involved with this issue several years ago when I was contacted by a constituent by the name of Al Lipkin. Al was dying from stomach cancer, and his condition was accelerated due to blood clots, which prevented him from continuing with chemotherapy. There was no cure for him, and he was going to die, and he wanted the option to die on his terms. He asked me to file legislation at that time to mirror what the state of Oregon did, and I did do that, and I filed it each session since in his memory because unfortunately Al passed away before we could even get a hearing that first session that we filed the bill. This particular version of the legislation allows for various things relative to end-of-life medication. The patient must have a terminal disease, meaning that it's incurable, irreversible, and within reasonable medical judgment will result in death within 6 months. They must have the ability to make and communicate informed and complex healthcare decisions. They must make the request to obtain the medication themselves. No one else can do that for them. And before they make the request, they need to be informed of their diagnosis, the prognosis, the potential risk for of the medication, the probable results of taking the medication, and the alternatives to taking the medication, such as comfort care, hospice, and pain control. The attending physician must refer the patient to a consulting physician for medical confirmation of the diagnosis. The patient must see a counselor to determine if the patient is suffering from a psychiatric or psychological disorder or depression that might impair their judgment, and no medication will be prescribed unless the counselor approves it. When the patient makes the request, it must be witnessed by at least 2 individuals in the presence of the patient, and the witnesses must attest that they believe the patient is capable of making the decision and that they are acting voluntarily and they're not being coerced into signing as witnesses. One of the witnesses has to be a non-relative that is not entitled to any portion of the patient's estate, does not own or work for the healthcare facility involved in the request, and is not the patient's attending physician. At any time during this process, the patient has the right to rescind their request, and the prescription itself cannot be written unless the attending physician provides an opportunity for the patient to rescind their request. And even after a patient receives the medication, they have the right to never take that medication and not to end their life in such a manner. We have, over the course of the 6 years, made some significant changes to the bill, and those changes have been with input from other people who have taken the time to contact us and are concerned about certain things. In previous versions of the bill, the patient only had to see a counselor if the physicians deemed it necessary. In the current version of the bill, it's now mandatory for a patient to be seen by a counselor, and unfortunately, when we were making the changes, we accidentally left in subparagraph 7 of section 12 of the legislation. So I request at this time, should the committee choose to release the bill, that they make a technical correction to remove the words "if performed." Previous versions of the legislation have stated that the doctor must list the terminal disease, as the cause of death. Having heard this concern during last year's testimony, The current version of the bill was drafted to include a compromise. This version requires that the doctor state self-administered due to whatever the underlying terminal disease is. And I'm open for further suggestions on any way to word this as compromise language. The majority of the other substantive changes have been made to this version, and the last one made to strengthen the safeguards. Feedback was requested from the Mass Developmental Disabilities Council. Their language was incorporated. I have a list of that language. I won't go through it now, but I will submit it to the committee so you know exactly what we changed with the input of the Developmental Council. My constituent Al Lipkin passed on October 22nd, 2009. I don't know if he would have chosen to end his suffering any earlier than that. But it is a choice that he never had, and I'm sure that he would be very happy to know that we are now, once again, testifying before the committee that would give the residents of the Commonwealth that choice. So I thank you for your listening. Representative Kaufman, do you want to say anything, or just...
Let me just say that by my presence here, I'm seconding the motion that you just heard from our colleague. And I hope this is the year when the committee is able to act on this bill and do so in a manner to give us on the floor the opportunity for a tough but ultimately important debate about this fundamental right.
Thank you. My name is Chris Walsh. I'm the representative out of Framingham, Massachusetts. This last year, late March, my mother passed after a 10-year sort of slide. Because we did hospice in the house, we kept her in the house, and I had an opportunity to be very close to the process of dying. The process of dying is extremely difficult to do with the kind of dignity that my mother lived her life. I hope that this committee can see through to allowing people dignity at the end of their life, and I thank you for your consideration.
Do members have any questions for the representative?
Mr. Chairman.
Representative Lott.
Thank you for your testimony, gentlemen. But I do have several questions, if you don't mind. How is this bill different than what the voters rejected in the last referendum?
It differs in many aspects, and some of them I alluded to during my testimony. I can provide you with a further list after the hearing is concluded.
So the bill is actually called the Massachusetts Compassionate Care for the Terminally Ill Act. So it's my understanding, and this is why I want to ask some of these questions, is it true that the patient will take this medication or could take this medication by themselves without anyone else around, without a doctor around, or is that incorrect?
No, as far as I know, that's the case. It's
So
the patient's choice.
So the answer to the question is a patient will take medication by themselves with no family members around, correct?
It's the patient's choice.
Right, so it's up to the patient, okay. And where did they get the medication? I just want to understand logistically how this happens.
They will
This is a terminally ill patient that goes to the doctor, to the pharmacy and picks it up, or?
They make the request. If they meet the qualifications and the criteria, then the medication will be given to them.
So is it one pill, or is it 5 pills, is it an injection, what is it?
From what I understand, it's a number of pills that they then have to empty into a liquid and then drink.
So they empty it into a liquid, and then what do they do with it? They
Drink it. Drink it.
And then what do they do?
They wait for the effects to take hold.
So I just want to, I'm really, the Massachusetts Compassionate Care for the Terminally Ill Act is what we're calling this bill. So so far what we know is that a patient will take this medicine by themselves with no family members around. Is that fair to say?
Can I point out that this is not fair at all? And excuse me, everybody. So, excuse me, Representative Lyons. The fact of the matter is, when my mother passed, she had many family members around her. When people make these decisions, they don't make them in a vacuum. They don't go off onto an ice floe. This is a situation where people are making these decisions within a family structure. Is it possible that someone could make it on their own if they're a sound-minded body? Yes, it's possible, but I think it's also very, very unlikely.
Well, Representative, that's not what the bill says. The bill says that an individual can make this and doesn't even have to tell their family. That's why I'm trying to get an understanding of what a person can and can't do. And in your situation, and there are plenty of situations, I had my parents both die, and I'm well aware of that process. But what we're doing is we're putting forth legislation, and we're calling it compassionate care for the terminally ill. And what I've just described, at least for me, and I'm sure to most, doesn't appear to be compassionate.
Compassionate
So that's why I'm trying to get to the...
to you.
Representative Lyons?
Excuse me.
We need to move on to it. Do you have a final question?
I do.
If you could please ask the question and then give the Representative time to answer, and then we will have to move on.
That's
A lot of people want to speak today. You will have the opportunity as a largest ask for a question.
So are patients who take this lethal medicine required to notify their family before they do it?
No.
Thank you, Mr. Chairman.
Thank you. Thank you, Mr. Costa, for your leadership here, Mr. Cochran, for your Walsh, condolences, and Oscar.
Thank you.
I believe Representative Ehrlich is
Mendelssohn. I am an autistic adult, one of the leaders of Second Thoughts Connecticut, sister organization to Second Thoughts Massachusetts. You should all have my extensive written testimony detailing many other flaws in the bill, one of which in fact was just mentioned by the lead proponent, and there are actually quite far more simple inconsistencies in it that you can see in my testimony. I want to focus in my oral remarks on the issues of disability discrimination and expansion. We in the disability community viewed legalizing assisted suicide as a violation of the Americans with Disabilities Act and Article 114 of the Massachusetts Constitution. People with certain disabilities are thus denied the equal benefit of suicide prevention services. In my written testimony, I cite the case of Nikki Bacharach, whose suicide was viewed by her famous parents, and I'll quote this full statement here. She quietly and peacefully committed suicide to escape the ravages to her brain brought on by Asperger's. Very creepy. It was not viewed as a tragedy. Regarding expansion, leaders of Compassion and Choices and other Right to Die organizations have publicly stated their intent to come back later to expand beyond 6 months, terminally ill, mentally competent. At a gathering in Hartford, Connecticut 1 year ago, Compassion and Choices president Barbara Coombs Lee declared her support for assisted suicide for people with dementia and cognitive declines, disabilities unable to consent. CT News Junkie quoted her saying, quote, "It is an issue for another day, but is no less compelling." Here in Massachusetts, Dr. Marcia Angel has written in the New York Review of Books that she now favors euthanasia as well as assisted suicide. Earlier this year, Oregon debated legislation that would have extended eligibility from 6 months prognosis to 1 year. If H. 1991 were enacted, expansion will move into the hands of judges who would easily use both the ADA and Article 114 in a different direction to require extending the so-called benefit of aid in dying to people with other disabilities. The limitations of self-administer 6 months terminally and mentally competent all discriminate on the basis of disability. And in my written testimony, I cite a letter from the Deputy Attorney General of Oregon as further evidence. So what about the person with ALS who has a 6-month prognosis but has lost the ability to literally self-administer? The justification behind the bill in Oregon. What about the person with Parkinson's disease who will have tremors for years before dying? Those with communication disabilities who may not be able to make the request on their own, grandma with dementia, the person with a severe psychiatric disability. Once the door to assisted suicide is pried open in enough states, Compassion and Choices will seek to open it further through the courts, going from 6 months terminal to 1 year to perhaps 5 years, from assisted suicide to euthanasia, and from euthanasia for terminal illness to chronic illness to mental suffering. This is how we go down the same road as Belgium and the Netherlands, where we see euthanasia for deaf twins who fear going blind, or for someone unhappy with gender reassignment surgery, and where euthanasia is the cause of 1 out of every 50 deaths. For Compassion and Choices, these are merely issues for another day, and for them, no less compelling. For those of us in the disability community, opposition to assisted suicide is an issue of justice and civil rights. Reject H. 1991, which enshrines lethal disability discrimination into law. Instead, let us recall Reverend Dr. Martin Luther King's dream, in which we all, regardless of race, religion, gender, sexual orientation, or disability, have inherent dignity, and we do not have to die to get it. We shall overcome.
Can you hear me? Is the microphone working? Maybe you can bend it down a little bit, Stephen. Bend it down. Can you hear me now? Is that good?
Yes.
I can try to put my microphone a little closer. How's that? Is that better?
Yes.
Great, thank you. Senator Lewis, Representative Hogan, and members of the committee. My name is Cathy Legon, and I'm here to voice my opposition to H. 1991. I hope that you will read my full testimony. I appreciate the opportunity to testify, but it's awfully hard to get such a complex issue into 3 minutes, as I know you know. To summarize my testimony, though, in Connecticut, we have defeated, actually crushed, similar bills to this for 3 years in a row after 12-hour hearings, because we know there are a lot of opinions on both sides, and each time we've defeated it more convincingly than the previous time. What happens is the more people know about physician-assisted suicide, the less they tend to be able to support it. First, let me say that my heart goes out to all the people who are here and who have testified earlier about the suffering that their loved ones endured. I'm not taking that lightly, not for 1 second. But the harsh reality is that those of us with disabilities will be the collateral damage in any system like this that's created. You will say that this bill applies only to people with terminal illnesses. Terminal is one of those slippery kind of words, though. Many of us with severe disabilities have experienced the willingness of healthcare workers to give up on us because they think that we are going to die soon anyway. If we go to the hospital, we bring friends. We have to. These problems are well documented, and the last thing we need is for doctors to start having in the back of their minds, well, maybe it's time for aid in dying. Proponents say that with adequate safeguards, no one outside of the target population is at risk. But as Stephen has testified, and in reality, no package of safeguards has ever or can ever be developed that will provide 100% protection from misdiagnosis. What if you act on this and the diagnosis was wrong? Incorrect prognosis. We've all known people who were given 6 months or a year to live and lived on for years. Coercion. People do die alone using this measure. How do we know what's happened without an independent witness there? And then devaluation of the lives of people with disabilities. Some of us every day need someone to change us, feed us, dress us, and not minimalizing the trauma of that to people who aren't familiar with it, but we do live productive and happy lives. So the question ultimately is it acceptable for some lives to be accidentally or inappropriately shortened so that others can exercise what they see as a personal right? The last thing I want to do is to interfere with anyone's personal choice. But when this choice becomes a bill that poses a direct threat to me and others in my network, we must all say no. One other thing. Proponents often say that there have been no problems with the Oregon and Washington assisted suicide systems, but this is false. A report from the Disability Rights Education and Defense Fund describes just some of the abuses, and these are the ones that got caught. Who knows how many have not gotten noticed because they didn't end up in the media. And so it shows that the existing safeguards there are a lot of times ineffective. There's a link in my testimony to that, and I hope that you will really read that. It's important. And finally, look at all the people with disabilities and our allies who have come sometimes a great distance to be here today to fight against this. We need you to understand that there is no such thing as a purely personal decision. Would that it were that simple. Although our hearts go out to the people that think aid in dying will help them or their loved ones, nonetheless, H1991 is bad medicine, it's bad for people, and it's bad public policy. It ought not to pass. Thank you for your time today, and after our panel, we'd appreciate any questions that you may have for us. Thank you.
Hi, my name is Nicole Stacy, and at the invitation of Second Thoughts, I came all the way from Hartford, Connecticut today for this matter of great public concern. I would like to tell you about a college friend of mine. You'll hear a lot of personal stories today, and I sympathize with all of them. This friend's grandfather committed suicide because he dreaded going to a nursing home. In a matter of weeks, I watched my devastated friend lose interest in his studies. He went from a good student in a challenging program to regularly flunking assignments. He was despondent. In his grief and guilt, he kept asking himself, why did Grandpa feel that he could not reach out to his closest loved ones? Well, I'll never know if Grandpa was terminal, but if you wonder why I'm telling you this, it's because reports out of Oregon about the law on which this is based consistently show that the top reasons people give for using it are not fear of inadequate pain control, but concerns about loss of autonomy and dignity, concerns that I imagine my friend's grandfather shared. I am, of course, moved by the stories of end of life gone terribly wrong. Who wouldn't be? We all know that there is much room for an improvement in our current system if it leaves people in such mortal dread. In a recent article, palliative care physician Ira Byock wondered why dying has to be so brutal. But this bill leaves the broken system intact and eliminates the patient, a great injustice. You may believe that this bill gives patients more choices, but actually what it does is set very limited conditions for state sanction of suicide. That idea cannot be easily contained. This is borne out by a recent study in Southern Medical Journal showing an increase in total suicides associated with legalizing assisted suicide. People realize that such distinctions in suffering are arbitrary and subjective. Would we long be able to diminish my friend's grandfather's suffering or question his judgment? Furthermore, I hope that you will meditate on this point. Do you think that my traumatized friend would be able to answer his question and find peace any easier if the message was pills instead of a noose or a gun. You may be told today that there is some meaningful difference between aid in dying and state-sanctioned suicide. I would add that my own definition of suicide comes from a standard dictionary, not from the Bible or anything like that. Deep down, do you believe that there is such a meaningful distinction? I don't, and that is why I'm asking you to reject H1991. Thank you.
Thank you very much, Paul, Cathy, and Stephen. We appreciate you coming all the way from Connecticut today.
Yes.
Thank you.
You're welcome.
On public health, thank you for this hearing regarding the dangers and serious unintended consequences of this bill. We four physicians from Worcester County, like the Massachusetts Medical Society and the Massachusetts Academy of Family Physicians, need to speak out in opposition to this misinformed movement. Like Margaret Mead, the great medical historian, we understand the ground-shaking consequences of what is being discussed today. We strive to focus your attention on the principles which are dismantled by this bill. I am Paul Carpentier, an ICU physician at Hayward Hospital in Gardner. I have 2 points. The first is that society should not want doctors to be involved in killing. The second is that the medical insurance industry and Medicaid would be allowed to use this law as an economic windfall by reducing patient choices. The principle of solidarity insists that we, the physicians, our legislature, and our citizens, care for the most vulnerable and protect them and strive to lift them up. That same principle of solidarity insists that those who need our help should not strive to change the principles of the entire establishment on which they depend. The principle that physicians do not kill their patients is foundational. It has led to all of the advances in medical science on which we rely today. President Jimmy Carter stated, "We must adjust to changing times and still hold to unchanging principles." My second and last critical point is this. Our public needs to realize that the proposed law would allow the insurance industry to extensively limit patient choices. I have served as a medical director for the largest and most successful ACO in the country. Some think that this proposed law would increase patient choices by allowing the option of prescribed death. Rather, since it would be doctor prescribed, the medical insurance industry will rightly see this as a state-approved treatment. Oregon Medicaid has already sent letters to numerous patients saying that, quote, "The treatment which your doctor recommended will not be covered, but we do cover the suicide drugs," end of quote. This is not solidarity. This is why they need physicians to be involved in assisted suicide. If doctors are not involved, then they cannot call suicide a treatment. In conclusion, suicide eliminates the person rather than alleviating the suffering. It can never be called a treatment. Join us in opposing doctor-prescribed suicide and help us to focus the public's attention on improving the excellence of palliative care in our Commonwealth. Thank you to the committee, and now on to my colleagues.
Good afternoon. My name is Laura Lambert. I'm a cancer surgeon and palliative care physician at the University of Massachusetts in Worcester.
Mr. Chairman, get her to speak in the
Yep,
microphone.
sorry. In my opinion, physician-assisted suicide is the equivalent of a personal death panel in a bottle, and it is also unnecessary. The stories of Brittany Mendenhall and Lauren Hill illustrate both of these points. As you all know, Brittany Mendenhall was a beautiful 29-year-old woman who moved from California to Oregon to avail herself of Oregon's physician-assisted suicide law after being diagnosed with an incurable brain cancer. Brittany made a promise to her family and to the world that she would take her own life on November 1st, 2014. Despite the fact that November 1st was, in her husband's own words, a good day for Brittany, she ate breakfast, she went for a hike with her family. She took the pills that were waiting for her and committed suicide just as she promised she would do. Based on my personal experience with many patients with advanced cancer, I know that Brittany did not want to die that day. Indeed, she told us this in a video the day before on October 29th. I cannot imagine the pressure that she felt to follow through on her promise, but clearly she felt it was her duty to die that day. Contrast Brittany with Lauren Hill. Lauren was 18 years old when she was diagnosed with an incurable brain cancer. Despite incredible physical and psychological challenges, Lauren accomplished her lifelong dream of playing college basketball for a half season, and she raised over $1.5 million for brain cancer research. She lived every day until, supported by hospice and her family, she died peacefully at her home a year later in April of this past year. Recent studies have clearly demonstrated that adding early concurrent palliative care to treatment for people with terminal cancers not only decreases suffering but significantly prolongs life. If passed, rather than encouraging our society to demand better palliative and hospice care, this bill runs the risk of creating a societal expectation of a duty to die, as we saw with Brittany. As our state's leaders, it is your duty to protect all citizens of Massachusetts from these personal death panels in bottles by not passing this bill. It is also your duty to ensure that we all have access to adequate palliative care and hospice services, for which this state is world-renowned. Thank you.
Members of the committee, thank you for this opportunity to speak to you today. My name is Mark Rollo, and I am a family physician in Fitchburg, where I have practiced for almost 25 years. I am strongly opposed to this bill for many reasons, but I will focus on two. First, this bill will put pressure on the vulnerable to choose death. Secondly, it attempts to coerce physicians to violate their conscience and the Hippocratic Oath if they refuse to participate in assisted suicide. The Hippocratic Oath not only says, do no harm, it specifically says, I will not give a deadly drug to a patient, even if asked, nor will I suggest such a thing. The reason it was so explicit was because assisted suicide was common in the time of Hippocrates, and he learned that physicians that would not have the trust of their patients if they had the power to kill as well as the power to heal. As a family physician, I am privileged to take care of people of all ages, many of whom are elderly, frail, and fearful of losing their faculties. Doc, don't get old. I'm tired of living. I feel like giving up. I don't want to be a burden. I hear statements like this all the time. Depending on the mindset of the physician and the legal environment, these statements can be taken down two entirely different pathways. Either a pathway of encouragement, hope, and support, or one of despair, abandonment, and death. It is easy to see how this suicide scenario would repeatedly play out in Massachusetts. Recently, a 93-year-old patient of mine who lived independently with her husband was admitted to the hospital with a very treatable heart rhythm problem. Treatable though it was, the episode was very exhausting to this woman, who was in a psychologically vulnerable state due to the recent suicide of her own son. She refused intervention and asked for comfort measures only from the ICU physician. This busy doctor, who did not know my patient, complied and withdrew treatment. When I learned what was happening, I visited her in the hospital, and because I knew her and knew her struggles, I was able to have her reconsider her refusal for care, and within a day, her condition was stabilized, much to the relief of her husband and family. She is now back at home with her husband, who said to me, "Thank you for giving me my wife back." If assisted suicide were legal, she could have requested a lethal script, a second opinion could have been obtained on the same day, a psychiatric consult would have found her competent, even if depressed. And since this bill does not require treatment of depression, a lethal prescription under this bill could have been administered on the same day. All of this could have been all of this could have taken place without the primary care physician even being aware. Furthermore, if the ICU doctor refused to participate, he would have been pressured to violate his own conscience because this bill requires transfer of the patient at the doctor's expense to a facility that would provide a lethal script. Finally, Massachusetts has a proud tradition of protecting the vulnerable. Studies show that it is the white, wealthy, and well-insured who favor assisted suicide because their choice will be expanded. However, it is the poor, people of color, the dispossessed, the disabled, who will inexorably be steered towards suicide. It is this ill-advised bill that should be killed. Thank you.
Amen.
We've asked several times to please not interrupt the hearing.
Thank you. I am Dr. William Lawton, a doctor in internal medicine and a specialist in kidney diseases and dialysis. I've cared for patients facing end-of-life decisions for 50 years. Today, I represent the American College of Physicians, the largest physician specialty group in the United States, which strongly opposes physician-assisted suicide. I will now focus on two areas. One, Bill H. 1991 is dangerous to doctors, and the bill is dangerous to our patients. This bill is not about giving patients the right to die. It is about giving doctors the right to kill. It gives too much power to doctors for us to be the judge, jury, and assistant executioner, unprecedented in our society. We doctors are not perfect. We're not held liable when giving lethal pills in this bill, which are known to have complications and are the same medications that have been used in executions as well. Fluorocidol in Oregon, the prescribing doctor was only present at death for 14 of 100 patients. This bill is dangerous for patients. First, hope in a medical breakthrough is abolished. I return again to Brittany Maynard, who suffered from the glioblastoma brain cancer. 4 months after her death, March 2015, the cover of Time magazine featured Mary Ann Anselmo, a 59-year-old woman also suffering from a glioblastoma. Time reported that with a new therapy at Memorial Sloan Kettering Cancer Center, her tumor had not grown in a year. In preparation to discuss this today, I looked at the latest data. An update 2 months ago, her Dr. Hyman stated, the latest scan of the brain does not show any tumor anymore. Also, doctors are frequently wrong in their prognosis. This bill specifies a patient must have less than 6 months to live. We in Massachusetts remember Senator Ted Kennedy and his brain tumor. He was given a few months to live. The doctors were clearly wrong. We remember Vicki Kennedy's ringing condemnation. Senator Kennedy returned to Congress and had 15 months of productive life and time with his family. Patients today in Oregon are living in fear in a new culture of death. Dr. Toffler, a physician in practice in Oregon for 35 years, recently wrote that the proponents of assisted suicide are wrong. There are problems. Patients in Oregon today live in fear, not knowing which physicians are now death doctors. The so-called safeguards are an illusion. In the Massachusetts bill, there's no waiting period. The lethal prescription can be written the same day as requested. And finally, as written, it has been discussed, in H. 1991, counseling is not required. Despite what supporters of the bill want you to believe, there are contradictions regarding psychiatric or psychological counseling, and the bill mentions, quote, report of counseling if performed. In closing, we in the Commonwealth of Massachusetts have been at the center of our nation's history. First among our unalienable rights is life. The committee that drafted these words included John Adams, who lived in Quincy, 11 miles from where we sit. I implore you to oppose H. 1991, to not destroy the dedication to life that is our medical profession, and the heritage of our Commonwealth. Thank you very much.
Good afternoon. My name is Dan Diaz, and I'm Brittany Mendenhall's husband. Brittany died on November 1st last year in Portland. The emotion just comes. Don't let her freak you out. I'm okay. Brittany and I are Californians. But last year we had to move to Oregon so she could access medical aid in dying in order to secure a gentle passing if it were to become necessary for her. We found out on New Year's Day of 2014 that Brittany had a brain tumor, that it was very large, and that there was no cure. She endured an 8-hour brain surgery, and we researched every treatment option that was available. But the tumor was growing aggressively. And had we stayed in California, the tumor would have ended Brittany's life in a brutal manner. Brittany did not want to suffer needlessly for the final few days or weeks of her life and die an agonizing death. She wanted her passing to be gentle and avoid the horrific and painful death that the tumor was already enacting upon her. Brittany passed away peacefully in her sleep on November 1st of last year. In January of 2015, the end-of-life options legislation was introduced in California. I stood next to an individual named Jennifer Glass at the press conference as she explained to everyone the lung cancer that she had been battling. Jennifer described the aggressive treatments that she had endured, the hard side effects that she had suffered. But most of all, she shared her desire to have some control over her dying process so that she could fear less at the end of her life. Jennifer died in California on August 11, 2015, just a couple months ago. On that Tuesday morning, I went to visit her and her husband, Harland. I sat at her bedside. I saw my dear friend that I had only known for 7 months, unconscious and withering away. She had not been given food or water for 5 days. The pain that Jennifer was experiencing from the tumor, which had now spread to her brain, had become unbearable. So at Jennifer's request, and at the advisement of her medical staff, she had been put into a terminal sedation 5 days earlier. That was the only option available to her in California. And it's the only option available to any terminally ill individual in all 50 states. Terminal or palliative sedation is the medical practice of placing an individual into a coma and then withholding food and water. The terminally ill individual then dies of dehydration, starvation, and whatever the cancer is doing to that person. Jennifer died later that night. But that was not the dying process that she had wanted. Why did she have to endure those 5 days of struggling and in discomfort? My wife, Brittany, passed away gently. Jennifer's death was not as gentle. In either case, it was the individual determining that it was their time. And in either case, the end result was the same: death. But the manner of getting there was quite different. Jennifer should have had the same option available to her in California as Brittany had in Oregon. Each of us, as individuals, should have the options of deciding for themselves how their final days will play out. A few months ago, the California Medical Association, the largest state medical association, removed all opposition to this program. And in doing so, the statement, they recognized that palliative and hospice care cannot always keep a person comfortable at their end of life. The medical community can no longer abandon terminally ill individuals like Brittany or Jennifer to die a horrific death. Death with dignity legislation allows end-of-life decisions to be made by the terminally ill individual and their physician, working within their own spiritual beliefs and with their family. It's offensive to hear people who would judge those of us that would want the option of having a gentle dying process. There are certain diseases that produce horrific and needless suffering at their end of life. Brittany's case was one of those. There is no glory in suffering a prolonged, agonizing death if that is not what the terminally ill individual wants. As a Catholic, I believe it is not for me to judge someone else's decision regarding their own end of life. And I respect those that might make a different decision if they were in Brittany's shoes. So I don't understand why they do not extend that same respect to those of us that agree with Brittany and Jennifer, that having this option should be one that is afforded to terminally ill individuals so they don't have to suffer needlessly at their end of life. In Massachusetts, 70% of voters agree that a terminally ill individual should have the option of requesting medical aid in dying. 64% of Catholics agree with medical aid in dying. The introduction of this legislation is an example of the elected officials of this state showing leadership and listening to the will of the people. My time is up, but if there are questions, and there's been a lot, I notice that my wife's name is brought up quite a bit. Feel free. Ask me about the program in Oregon. Ask me about terminal sedation. I've seen it firsthand. Ask me about the safeguards and how protected Brittany felt. I thank you for your time.